Chap. Vi. of controverting the commission. A commission of lunacy may be controverted by petition to supersede it, to traverse it, or for an issue to try the fact at law. The traverse of an inquisition is matter of right at law, by 2 ed. Vi. c. 8. s. 6. And is no favour, but to jury, and carries the fact to be tried at common law. It is a short process, stating the inquisition, and taking the common traverse upon it, and the Attorney General joins issue. The verdict, or finding, must be correspondent to the issue. An inquisition is always admitted to be read, but is not conclusive evidence, because it may be traversed. Where there is any mistake in the execution of the commission, it must be examined into, and the court, if they see cause, may quash it, and direct a new commission, but there is no melius inquirendum, for that is only grantable on the part of the Crown, which cannot traverse as the subject can, and therefore the court directs a new commission. If at the second inspection, the lunatic appears better than he did at the first, and this does not prove him to be fool or madman, the finding must be accordingly. Fitzhuber 10 Br. shows, that it is a common method to inquire by inspection, after an inquisition returned, and there have been many cases of that sort, but if upon inspection the Chancellor is at all doubtful, there ought to be some better method of determining it, and the statute of Edward Vi. seems to be made for that purpose. If any person be, or shall be, untruly found lunatic, and see all persons grieved, or to be grieved by any office or inquisition, shall and may have his or their traverse to the same immediately, or after, at his or their pleasure, and proceed to trial therein, and have their high remedy and advantage as in other cases of traverse, upon untrue inquisitions or offices founden. But, although the party is thus entitled to traverse, he must come to Chancery for leave to suspend the custody. To try the question by an issue, is of greater expense than a traverse. A traverse is binding upon the lunatic, but not upon him to whom the grant of the custody of the land was made, who claims as a purchaser. It would certainly be productive of great mischief if this grant was suspended on slight grounds, but the court have always exercised that right on serious and well-grounded applications, and if anything has been done already, it will abide the event of the traverse. There is no case where an idiot has traversed by attorney, though many where a lunatic has, and therefore an idiot appears in court in propria persona, when he asks leave to traverse, but a lunatic does not, and there ought by 18 Henry Vi. c. 7, to be a month's time between the return of the inquisition and the grant of the custody of the land, in order that parties may have time to come in and tender such traverse. In all these inquisitions they are not conclusive, for the parties may bring actions at law, or file bills in equity, to set aside conveyances. Therefore it is better to bind the party to abide the issue of a traverse when the court thought it a hard case. In Idocy, the custody was not granted without leave to traverse the inquisition, by Lord Chancellor King, and peculiar circumstances will guide the court in this discretion, as the expense and income, where an estate lay in the West Indies, of changing the management, and where a person was found lunatic under 2 inquisitions, and the court would not allow a traverse of the second. Not only the lunatic, but his heir, is bound upon the traverse, or it would have been a very fruitless act of Parliament. A trial, by inspection is the proper trial by the Lord Chancellor, as to the person, when there has been a solemn trial in the lifetime of the lunatic, who is bound himself, to say that, after his death, when he cannot appear in person, and cannot be inspected by a jury, it should still be open to a traverse by the heir at law, carries a great absurdity with it. The alienee of a lunatic may traverse on inquisition, as well as the lunatic himself. Suppose both of them traverse, and he is found a lunatic at the time of the alienation. The alienee is certainly bound. It is said that he is bound, because he is a party to the first, but that the heir at law shall not, which would be a manifest injustice, and still stronger in the case of idiocy, where the Crown grants the custody and profits of the estate. During the idiot's life, the idiot dies, and according to the doctrine attempted, the heir at law might come in and traverse the idiocy, but the executor of an idiot cannot have an account against the grantee for the profits incurred during the grant from the Crown. The lunatic is bound, and cannot traverse the Inquisition when he recovers his senses. If the grantor was really a lunatic at the date of his grant, it is absolutely void, and if void, so as not to pass the estate, it is void, so as not to bar an entail. But a common recovery might have a different operation from a deed to lead the uses, for a common recovery will bar the entail though there be no deed to lead the uses, because it is in respect of the satisfaction of estate in value which creates the bar. Yet if such a deed as this does not pass the estate, then the deed can have no operation, as a recovery of an estate in satisfaction. But a letter of attorney, executed by the lunatic, which is a deed, though revocable, yet is very different from a common recovery, and therefore everything done in pursuance of it is void, as was determined in Whitworth and Comely, 1744. But if he be found, not a lunatic, only a weak man, and the deed was obtained by fraud or imposition, the court must, on a bill filed after his death, take it exactly in the same light as it stood before his conveyance. If the alienee gains no right by this deed, he can convey nothing to the trustee under the order of court, therefore the heir at law is not injured. But if the entail is barred, those uses are not existing, and no prejudice can arise from the conveyance directed by the court. A conveyance made to a trustee for the lunatic is good but will not bar any right which the heir at law might appear to have on a trial at law. N. The committee cannot join issue on esse faces, to traverse the commission, but it must be in the lunatic's own name. If, upon a traverse, the party be found not a lunatic, at the time of the commission issuing, or it be superseded, before any part of the property could vest in the crown, no costs will be allowed to the party taking it out, however meritorious their intention, for there is no fund out of which the costs can be taken. An order on a petition in lunacy cannot be made for sale of real estates to pay debts, so as to prevent a bill by creditors. It must be done by bill. The proceedings on the commission are on the law side of the court, and can only be redressed, if erroneous, by writ of error in the regular course of law. When a lunatic traverses the Inquisition, he is to be considered as a defendant, opposing the title found for the crown, without setting up any in himself, as he must do in a petition of right, and the record must be carried down to trial by the prosecutor of the commission, for the lunatic cannot be deemed a plaintiff, and so have power to delay the crown, and if illness prevents his appearing at the trial, and a verdict pass for the crown, on no defense, the court will grant a new trial. Rex v. Roberts. A lunatic having made a different appearance, on the second time of his being inspected, was allowed to traverse the Inquisition, and the grant of the custody was suspended. Upon the return of the traverse to the Inquisition, finding that the party was a lunatic at marriage, and at taking the Inquisition, but at the time of a verdict directed as to the fact, was not a lunatic, the commission was superseded, but the court doubted the propriety of such a double issue. Ex parte fern. An entire stranger, and having no interest, cannot traverse a commission. The court has never been in the habit of discouraging any fair and reasonably provident application with regard to the situation of a person allowed to be a lunatic, if he is more pressed in the execution of the commission than a tender and humane consideration of his circumstances would authorize, or of a person not allowed to be lunatic, but made the object of a commission. The law has provided that no person shall be in such a situation deprived of his liberty in the administration of his affairs, until the fact is ascertained by a proceeding admitted to be ex parte, which the law supposes may collect mistakes smile and therefore has given a right to certain persons to traverse the Inquisition. C2 ed. Vi. C. 8. S. 6. And as the true interest of lunatics is not consulted by persons, who act upon their own views of the sanity or insanity formed upon occasional conversations, and come too rashly to the court without sufficient inquiry, yet it is the duty of the court not to censure too hastily any application upon a subject so very important as this, but costs will be granted, if pressed for by the other side. A person who has entered into any contract with a lunatic, is deemed to have such an interest as to entitle him to traverse the commission, for such a person having become a bona fide owner in equity of his property, must necessarily be aggrieved by the finding, and he may show that the party never was lunatic. Lord Dalton. Where a person having, for several years since the date of the finding, with the knowledge of all persons who had any interest in, or feeling about, the management of his affairs, done all the acts the most sane man is entrusted to do, and with regard to his amusements, occupations, mode of life, and every circumstance belonging to the question of sanity, been permitted for years to act at his own discretion, without any providing, and so long as a particular topic is not mentioned, his family permitted him to act without restraint, is scarcely to be deemed lunatic. There are persons who are insane upon particular points, who, if these points are not touched upon, act discreetly in their own affairs, and even as trustees for others. Still it may be wise not to quash commission issued against them, but give them the right of trying the facts by a traverse. It may be quashed or traversed for not having been executed in the county near his abode, and competent notice given of it. There is no part of the duty, said Lord Eldon, ch. that occurs in the exercise of this jurisdiction, more unpleasant, and requiring greater caution, than that of determining when a commission should be superseded, for though you may, upon evidence, arrive at a safe conclusion, establishing lunacy, it is very difficult to determine when the mind is restored, depending upon the circumstance, whether the party is led to those topics upon which it was affected. In the case of MRSB, v. Lord Thurlow said, that where lunacy is once established by clear evidence, the party ought to be restored to as perfect a state of mind as he had before, and that should be proved by evidence as clear and satisfactory. I cannot agree to that proposition, either as to property, or with reference to such a case as this, for suppose the strongest mind, reduced by the delirium of a fever, or any other cause, to a very inferior degree of capacity, admitting of making a will of personal estate, to which a boy of the age of 14 is competent, the conclusion is not just that, as that person is not what he had been, he should not be allowed to make a will of personal estate. There may be frequent instances of men restored to a state of mind, inferior to what they possessed before, yet it would not be right to support commissions against them. On the other hand, if lunacy has been satisfactorily established, particularly where there is a tendency to do great personal harm to others, I ought to be sure, by the evidence of persons having competent knowledge upon the whole of the subject, that there is an absence of that disorder, and those tendencies may not be brought forward, when it may not be generally known, that there is any providence of the law thrown over the individual. There may be considerable evidence of the recovery, but if the whole nature of the case has not been stated to the physician, who swears that he has frequently seen the petitioner, and believes him to be of sound mind, unless he can go further, and state that the ground of the opinions of those medical gentlemen who thought otherwise, was laid before him, that he has had an opportunity of considering it, and the result of the whole is, that just and accurate as those conclusions were, or inaccurate upon his own conclusion, satisfactorily formed, the present state of the party is as he represents it, unless the affidavit comes with some such exposition, though the conclusion may be right. Not having those particulars before me, I cannot try the truth of the inference. The question may be, whether the existence of the commission may not be necessary, in order to secure to the party the utmost comfort and happiness he is capable of enjoying. An issue was therefore directed. It is understood that if an idiot has title to land, either by entry or action, and has it not in possession, the king does not seize it,